No, Your Honor.
The court has reviewed the report. I will note the defendant is 36 years of age. These are his first felony counts and charges and convictions. His LSI score was a 20, which puts him in the moderate risk category, and he does not have any substance abuse issues. The mental health evaluation that was done, the GAIN-I, indicated no mental health issues, but the psychosexual evaluation did indicate that there was an adjustment disorder with depressed mood and personality disorder. PSI recommended prison. The psychosexual evaluation indicated that the defendant was of moderate risk of reoffending and is in need of sex offender treatment. Having reviewed the pre-sentence report, the psychosexual evaluation, and the plea agreement, the court is willing to accept and be bound by the plea agreement in this matter. That would mean that Mr. Williams would be sentenced to 20 years fixed on each count with an indeterminate life on each count, with those charges running concurrent. Court would have discretion as to fines. Costs on each of the count are determined by statute. They amount to $545.50. Court would then have its discretion on a civil penalty under 1953-07. With that announcement, Mr. Browning, is there any argument by counsel?
Yes, if I may, Your Honor. I'm going to say, Your Honors, this was a tough case. I had a number of discussions with Mr. Williams, and the plea agreement, I appreciate that the court is willing to go with the plea agreement. This was a very difficult decision to come to. It was a very difficult decision for Mr. Williams to come to as well. Frankly, he's terrified of what he's facing in prison, and I can't give him much consolation on that. That is a consequence of his actions. He realizes that. And that's all I can tell you. He's terrified of what's coming. And under the circumstances, I think the plea agreement, the sentence, is appropriate, and that's all that I think that's all that needs to be said. And I appreciate that the court will go with the plea agreement.
Right. Mr. Cousin, the state have any statements?
Thank you, Your Honor. With regards to your announcement that you are willing to be bound by the plea agreement, I don't have much in the way of argument. I do have one more request, Your Honor, and that would simply be that the court entertain entering the maximum civil penalty of $5,000 under Idaho Code 195307 in favor of the victim and her mother in this case. I understand that in terms of collecting that or anything, that would be difficult at this time, but I think that would be inappropriate given the crime. Thank you.
Mr. Williams, do you wish to make a statement on your own behalf, sir?
Yeah.
I didn't understand what you just said.
Yeah.
You do? Okay, go ahead, sir.
I'm sorry for what I have done. I wish I could go back and change it. And yeah, I wish, like I said, I really wish I can go back and change my actions. But I'm here, so trying to make everything better.
Right. Anything else, sir?
No.
Mr. Williams, are you satisfied with Mr. Browning's representation in this case?
Somewhat.
Okay. What issues did you have?
I don't know. I just think he could have done a little better maybe on the plea, but understanding all the stuff, but it is what it is.
All right. You understand you're the person that makes the decision on whether to accept the plea agreement or not, right?
Yeah.
And you had those discussions with Mr. Browning?
Yeah.
And you understand some of this is not within his control because the state is only willing to do certain things too. You understand that?
Yeah.
Any other issues that you had with Mr. Browning that you want to tell me about?
No.
Okay, that's the only thing. Okay. Do you know of any legal reason why I should not sentence you today?
No.
Mr. Browning, do you?
No, Your Honor.
Mr. Cousin, do you?
No, Your Honor.
Mr. Williams, based upon your plea of guilty to this judgment of the court, you are guilty of the crime of lewd and lascivious conduct with a minor child under 16, as outlined in counts 1, 2, and 4 of the information. I've indicated to you the basis of this court's acceptance of the plea agreement by reviewing the factors outlined in the pre-sentence investigation. Those are the primary things that I rely upon when considering the objectives of criminal punishment, which includes protection of society, deterrence, rehabilitation, and punishment, as well as the criteria under Idaho Code 1925-21 relative to that question of whether I should place you on probation or confine you to prison. I've weighed all of those factors in determining whether to even accept the plea agreement that you've outlined. Needless to say, the conduct that you engaged in is an abhorrent conduct, and it is simply not, there's just no excuse for that. And the plea agreement that has been presented, I think, is adequate to to address all of those concerns: deterrence, punishment, rehabilitation, and so forth. Therefore, it will be the judgment of the court that on count 1, that you be sentenced to a fixed and determinate period of 20 years with an indeterminate period of life. You're fined the amount of $2,000. Court costs are $545.50. Pursuant to Idaho Code 19-5307, you will be ordered to pay a civil judgment in favor of the victim of these counts, and it will work as a judgment against you in the amount of $5,000. As to count 2, you're sentenced to 20 years fixed, an indeterminate period of life. You're fined $2,000. Court costs are $545.50. On count 4, you're sentenced to 20 years fixed, an indeterminate period of life. You're fined the amount of $2,000, and court costs are $545.50. Those sentences will run concurrently with one another. Under Idaho law, you're required to register as a sex offender, and you're ordered to provide a DNA sample and thumbprint to the state pursuant to statute. Court is going to impose the sentence on each of those counts. Mr. Browning, has the court followed the plea agreement?
I believe you have, Your Honor. Thank you.
Mr. Cousin, has the court followed the plea agreement?
Yes, Your Honor.
Are there any questions, Mr. Cousin?
No, Your Honor.
Mr. Browning?
No, Your Honor.
Mr. Williams, do you have any questions?
No.
All right. The plea agreement provided that you waived your appellate rights, but I'm still going to notify you of those rights, and you can discuss those matters with Mr. Browning. You're advised you have the right to appeal the decision. That appeal has to be filed within 42 days. If you need counsel to represent you on that appeal, you can apply to the court to have counsel represent you on that appeal at no expense to yourself. You have the right to seek relief under Idaho Criminal Rule 35. That motion has to be filed within 120 days of entry of the judgment, and you may have the right to seek relief under the Idaho Uniform Post-Conviction Relief Act. That has to be filed within 1 year from the date your appellate time expires. You understand those time frames?
Yes.
Do you have any If you have any questions about those rights, discuss them with Mr. Browning. If for some reason he's not able to discuss those matters with you, you can ask for counsel to be appointed to answer those questions. Do you understand that?
Yeah.
Mr. Cousin, you indicated that there were no witnesses. I don't see anybody in the courtroom or in the waiting room. I assume the victim did not want to make an appearance or statement today to her representative.
That's correct, Your Honor. We have been in contact with the victim and her mother specifically. They have elected not to appear in person today. It's my understanding they may be viewing from the live stream.
Okay. Mr. Browning, anything further at this time?
I do not, Your Honor. Thank you.
Mr. Cousin?
No, Your Honor.
Mr. Williams, at this point, then, you're remanded to the custody of the Bingham County Sheriff's Office to be transported to the proper agent and authority for execution of this sentence. Your excuse, sir. Court will be in recess. We'll reconvene in, what time's our next hearing? We'll reconvene at 2:30 through Zoom. And that will conclude the